Magandang hapon. I'm Mike Schimmel, the Consul General of the United States. Welcome to the Visa Hour, your opportunity to tweet with the Consul General. And I want to say as we begin, Kumusta kayong magagandang tao sa Pilipinas? And that's probably as much Tagalog as you'll hear me say this afternoon. But I am learning, and I hope before I finish my tour here, I'll be able to address you in Tagalog a little bit more confidently. When I first arrived at post and knew nothing of the language, I asked for some help introducing myself from one of the consular assistants. And I said to her, I want to tell this audience that I'm the Consul General of the United States. How do you translate that? How do you say it in Tagalog? And my colleague said, that doesn't translate precisely into Tagalog, but you might try this. Ako si Mike Schimmel, hari ng mga visa. And that seemed to work pretty well. But today, as I mentioned, I'm not going to speak Tagalog. I'm going to speak English, my only dominated language. And I want to invite you to ask any questions related to the visa process, immigrant or non-immigrant, any aspect of the operation, the procedure. We want very much to demystify the process. We want people to understand what's involved because we hope that all our friends in the Philippines visit us in the United States. It's the best way we know to promote good bilateral relations and mutual understanding. We certainly enjoy, as Americans, visiting this country, and we hope that you will visit us in the United States and promote a friendship that is centuries old. To ask me a question related to visas, send a tweet, and I'm sure all of you are familiar with tweets. You're watching me on a webcam broadcast, so certainly you dominate social media. You can send through twitter.com using the hashtag #TheVisaHour. Make sure as well that you like us on Facebook. We are up to almost 50,000 friends, 50,000 BFFs. OMG, that is a huge number. And we do take note of those people who help us cross the milestone. Number 40,000 got a special greeting from the ambassador. Number 45,000 got a nod on Facebook. Who knows who will be number 50,000? I don't think it will be Lady Gaga or Charlie Sheen because they friended us last month. But it could be you. So please like us on Facebook. We'd be very happy to have you among our 50,000 friends. And I encourage you as well to follow our blog. Today, I hope I'll be able to answer all your questions, but I know there'll be more. And we have a blog dedicated exclusively to visas. It's called Visatisfied Voyager. And you can find that at blogs.usembassy.gov/Philippines. And you'll find connections to it on our Facebook page as well. So when you find U.S. Embassy Manila and you like us, you'll find links to our Visatisfied Voyager blog. And we hope that you will join in the exchanges, the dialogues, have your questions answered, and leave us your input. And now I welcome your tweets. And I see the first one on the screen before me. And the tweet is from Definitely Mai. Can I petition my soon-to-be spouse? I'm still a fresh green card holder here in the United States. How long is the processing time? Thanks. Soon-to-be spouse. If this were February, I'd say you're in for a very special Valentine's Day. Since it's January, I'd say you're in for a very special New Year with your soon-to-be spouse. It's wonderful to know you've found your one true love. Certainly what we're all looking for, what I'm lucky enough to have found, and what many of my colleagues are lucky enough to have found. But back to the issue. Can you petition your soon-to-be spouse? You have a green card. That means you're a legal permanent resident. As a legal permanent resident, you are entitled to petition certain people in your family, but regrettably, your soon-to-be spouse is not one of those people. The fiancé petition is not available for a green card holder. It is for a citizen. So since you're a fresh green card holder, you have a little time to go before you become a citizen. You could not petition your fiancé. However, if the two of you proceed to the marriage ceremony, God bless you both, and we wish you the best of happiness. At that point, you could petition for your newly married spouse. And that spouse would fall into the category of the spouse of a U.S. legal permanent resident. And once the petition was approved by the U.S. Citizenship and Immigration Service, your spouse would go into a queue because that category is oversubscribed. And if some of these words confuse you, you can seek clarification to the USCIS website, but oversubscribed really means there are too many people in that category to be processed in a timely fashion. And it would take 2 to 3 years for your new spouse, your one and only, your reason for being, to get to the front of the queue and be able to live with you legally in the United States as a legal permanent resident. I hope that answers your question. We have a tweet from Sheila. Is it really hard to pass the B2 visa interview? Well, one of the purposes of my appearance today on this broadcast is to assure you that it is not really hard to acquire a U.S. visa. And really, pass isn't the right word. What you really mean is it really difficult to qualify for a U.S. visa through the interview process? In fact, you'd be interested to know, last year we had 200,000 visa applicants, and 3 out of every 4 of those applicants were issued visas to visit the United States for a temporary purpose. 3 out of 4. So you tell me, does that suggest that it's difficult to get a visa? 75% of the applicants emerged from the interview approved for their visas. To get the visa, you simply tell the truth. If the truth corresponds to the qualifications needed for the visa, that is, I'm going to the States for a short purpose, this is what it is, and these are the reasons why I'd come back to the Philippines, you're going to get the visa. If your purpose in traveling, in fact, is something other than what you're describing, of course, we won't be able to issue you the visa because we have 2 purposes in the visa line. Promote legitimate travel, and as I said, we very much want every Filipino to come to the United States sometime in his or her lifetime. But we also have the obligation to impede travel that is not legitimate. In other words, someone who's trying to circumvent the immigration process, someone who's trying to integrate into an underground economy, look for work, or stay in the United States indefinitely, or effect some sort of criminal or insidious activity while on U.S. soil. So those twofold purposes merge in the interview process. And again, those people who are going for legitimate purposes and are truthful in their display of those purposes during the interview will be issued a visa. And I hope that helps answer your question. And I have another tweet. This is from Sanera Lynn. Consular officer told me to send an affidavit from a joint sponsor. Can my hubby's friend sign the affidavit? So this is an immigrant visa case. An immigrant visa is someone going to the States. An immigrant visa applicant is someone who wants to go to the United States for the rest of his or her life, presumably, to reunite with a family member. Say it's a spouse or a parent or a grown child. Those people are immigrants. And the United States, of course, is a nation of immigrants. We welcome immigrants. Last year, 60,000 Philippine immigrants moved to the United States with their new visas, and we hope as many do this year. But before those immigrants can come into the United States, the U.S. taxpayer requires that they display means of support to help them get started, because the taxpayer, generous though he or she may be, is not able to sustain the needs of so many immigrants, whereas their family members in the United States have to be, or they wouldn't be promoting their immigration. So we require the sponsors of these immigrants to submit what's called an affidavit of support. The affidavit says, I have the following resources available. They exceed the poverty line minimum, and they are ample enough to support my loved ones coming to join me. Sometimes, though, the person sponsoring the foreign national doesn't have enough money, but still wants to reunite with his family member from abroad. In those instances, the law allows the person to submit what's called an affidavit of joint support. I can't support my wife, for example, in her first year in the United States because I just got out of college and my income is meager. But my parents have ample means, and they very much want to have my lovely wife become part of the broader family. So they support the notion through what's called a joint affidavit, or an affidavit of joint support. So your husband is in the States, he's making a modest income, but he has a friend who is wealthy or has means enough to support yet another mouth to feed for a little while until that person gets launched. He can certainly have his friend submit a joint support affidavit. It's called a co-sponsorship or an affidavit of joint support. So the answer is yes, and I hope my explanation clarified things rather than muddied the waters. Another question, I can't quite read the name. Yunses, I think. The question is, how long is the holding period in the airport when the immigration officer looks into the immigration packet? Oh, that's an interesting question. I should tell you that I am an experienced veteran of this process because my wife is a British national who immigrated to the States carrying with her the same immigrant packet that today someone leaving our consular section would be carrying. What's in the packet? All the documents that attest to the validity of the visa that's in the passport the traveler is carrying. That includes the results of the medical examination, the results of the security check, the affidavit of support, and various other documents that endorse the eligibility of the traveler. So that traveler gets to the United States, goes into a queue like any other traveler, but when this person gets to the Customs and Border Patrol agent, he says, "Oh, you're immigrating to the United States. Step over to that queue there because they need to review what's in your packet." And they leaf through the packet and make note of the different documents of support. How long does it take? I really couldn't give you an accurate estimate, but if you have a connecting flight, I would give myself at least 3 to 4 hours. It might not take that long, but I wouldn't want to be anxious about it. Usually I would guess, in my experience, it took about an hour, but it might take a longer time if they're busy. So you wouldn't want to cut it short. I'm sure you'd be anxious enough traveling to a new country for a new life in any case. So give yourself as much time as you can between connecting flights so that the process can be completed in a comfortable pace. I have a query here from Soup 10. I wonder if that's some connection to Shamsi Soup, who of course is a beauty queen that all of the Philippines celebrates. We celebrated her last night in the People of the Year Awards at People Asia magazine. And while I'm on that topic, pardon me while I digress, I want to commend the committee for having awarded the People's Choice Award to Maruksa Pita, a Philippine woman who's been serving the needs of children in Manila for over 20 years, educating street people and doing wonderful things, a winner of the Mother Teresa Award, and last night commended in the People Magazine Awards. But back to the issue here. Soup 10 wants to know, what year are now processing immigrant petition for relatives? As I mentioned earlier, there are categories of immigrant visas, and many of them are oversubscribed. That means there are too many to be processed in a timely fashion, and there are waiting times for each of those categories. You haven't specified which category you're asking about. I mentioned earlier, for example, the spouse of a green card holder would wait about 3 years. The married son of a U.S. citizen or daughter of a U.S. citizen would wait 14 years. The married son or daughter of a green card holder, curiously enough, would wait less than the time in queue by a citizen because of the nature of the numbers of people in those categories. But that too would be over 10 years. So some of the categories are way, way oversubscribed. I don't know which one you're asking about. They're all listed on the DHS website or the CIS website, uscis.gov, and you can get an idea of how long the wait time is in each of the categories. The longest category, regrettably, because there are many, many, many people in this country in this category, is the category for siblings, the brothers or sisters of a U.S. citizen, only citizens, not green card holders. The queue to get to the front for processing in that category is almost 25 years. So it's quite a long time before people would get to the front in that category, and that's among the reasons that many people are enthusiastic about proposals for immigration reform, because a 25-year wait hardly facilitates family reunification. We all acknowledge that. Here's a question from Pinoy. There should be someone in your embassy that could reassess our application if we really are not qualified for a visa. That's a very good question, one that I'm often asked. If I am refused a visa, what recourse do I have to demonstrate that the officer's decision was not correct? First, let me assure you, as I mentioned before, only 1 out of 4 applicants at our embassy is refused. That refusal does not stand unreviewed. At the end of the day, the officer in charge of the visa section looks at every refusal and determines whether or not it was effected correctly. If you've been to the visa window, you've probably seen the officer is word processing while he or she speaks. The officer's taking note of what the applicant says. In addition, there is your application with lots of information on it. So the officer is typing into the system the reasons why there may be some doubt as to this person's eligibility for a visa. For example, he may type in, woman says she's going to Las Vegas to spend time with her boyfriend who does not have a job there but hopes to get one soon. She, in fact, is interested in studying there, and the two of them together are going to explore student possibilities. The officer might suspect that once she gets there, she'll remain there indefinitely and possibly pursue studies, possibly get a job to help her boyfriend. So he would type in some of the things that the applicant told him that makes him consider her ineligible for a visa. At the end of the day, the supervisor would look at those notes and he'd say to himself, this looks like a good refusal, or he might say, this refusal needs review. And if he decided it needed review, he'd call the officer in, ask a few more questions, and then invite the applicant in again for a second interview to see if in fact the person does qualify. So already there is someone in the embassy who determines whether or not the refusal is correct. If even after that review you haven't heard anything and you're convinced that a mistake was made in your case, you can reapply, which I know is an inconvenience because you'd pay a new fee and subject yourself to a new interview. But that's really the best way to go about it, because at the window you'd be able to have an opportunity to convince a different officer that the first decision was wrong. Failing that, if you wished to write to us, you could do so, but I could not guarantee any outcome there other than a suggestion that you reapply. So you may bypass that by simply coming to the window a second time. Of course, it's an inconvenience, but it's really the only way that you could get the visa reassessed, by applying again. And I know that doesn't satisfy everybody, but that is the way U.S. visa law works, and I commend it to you for review and appropriate action. Here's a tweet from Bill Mavick. Is it possible to obtain a B2 visa from a U.S. consulate or embassy in another country while situated or working in that country? First, let me explain what Bill means by a B2 visa. Most of our visas are issued as B1/B2 visas, and most of them are issued for multiple entries over the course of a 10-year period. So let me emphasize, we know it's inconvenient to come to the embassy to get yourself a visa. We do our best to minimize the inconvenience. You've all seen probably by now our lovely new facilities. Our new building is a magnificent structure. It opened last March. We're coming up to its first anniversary. Second largest in the world, ample space for all our applicants. We think the experience is much less unpleasant since we opened that building. But back to the issue. We still want to reduce the inconvenience further, so we take advantage of visa reciprocity so that if you are issued a visa, most likely you won't have to return to renew that visa for a full 10 years. So once every 10 years, you'd have to go through a visa process. A number of Filipinos, a significant number, of course, 10% of the population, I understand, reside in other countries. We all are aware of this. Some of them may decide that they want to visit the United States directly from one of those countries. Can they solicit a visa from the country where they're working, living, visiting, instead of the country that is their permanent home, the Philippines? The short answer is yes, they can. Any applicant is free to apply for a visa at any U.S. diplomatic post. So if you're in Moscow and you suddenly decide you want to go to Disneyland in California, you can apply at the U.S. Embassy in Moscow. Let me qualify this a little bit. Remember, the officer who's interviewing you is going to try to determine that you have good reason to leave the U.S. in a timely fashion and return to your country of residence. If you're outside your country of residence when you apply, it may be more difficult to convince the interviewing officer of your intent. So have that in mind. If you're outside your usual place of residence, it may not be the best venue for you to seek a U.S. visa simply because it will be difficult, or a little bit more difficult, to demonstrate that you have ample reason to return. If you're already in Russia, for example, I would have to ask, and in many cases it'll be easy to demonstrate. You'll simply say, I'm working here. I have a contract here for 2 years, but you can see I go back and forth to Manila all the time. It's unlikely that I'm going to abandon my circumstances. I'm enjoying my overseas worker status. So I hope that helps explain. It's open to anyone, but certain circumstances require you to consider your possibilities at those places.